adverse employment action?
That happens in an employment context. Essentially, it could be anything that impacts the terms of your employment, whether you're being written up, suspended, or terminated, or demoted. All of those could count as adverse employment actions.
Burden of proof.
That essentially means who has to prove what and what's the standard that they have to prove it to. So burden of proof in an employment case, very different than burden of proof in a criminal trial.
Pretext.
That's essentially a way to say that the reason your employer gives for terminating you or suspending you is a false reason. It's pretext. They're using it as an excuse, but it's not the real reason. And the real reason is something that's discriminatory or retaliatory.
Waiver.
That's when you're giving away or waiving either a legal right or the argument to make a legal argument later on.
Arbitration.
An agreement to take your legal dispute and have it decided by a private company or judge.
Statute of limitations.
The deadline you have to bring certain claims. In many employment contexts, there's different deadlines that are called statute of limitations at around 2 to 3 years.
Good faith.
That means you had an honest belief. You can be a whistleblower and say that you think something illegal happened. You could be wrong, and that's okay. You're still protected as long as you can show you had a good faith belief that what you were saying was true.
Mitigate damages.
That would require you to try to go out and minimize the amount of damage. So if you're wrongfully terminated, that means you should go look for other jobs and keep track of your efforts.
Discovery.
The process in which the parties exchange information before trial. In California, nobody's really being surprised at trial, so when you see TV shows where there's all this surprise evidence coming in, that usually doesn't happen. There's the discovery phase. We ask for all the documents on both sides, as well as what testimony is going to be given.
Depositions.
A test of the testimony you would give at trial, so you're under oath. It may be in a conference room, but you have penalty of perjury. Everything applies to you, and you have to give your testimony then based on what the other side's lawyers ask you.